Hello, I'm Cornell Clayton. I'm the director of the Thomas S. Foley Institute at Washington State University. And on behalf of the Institute, I want to welcome you out to our event today, which features a conversation with Washington's Attorney General, Bob Ferguson. Before I introduce our guest today, I need to make a few quick announcements. First, our applications for our graduate student research fellowships are due this Friday, April 2nd. If you have any questions about those fellowships or the application process, you can send us an email. The Institute's annual report is also out, and if you did not receive a copy in the mail, you would like one, please send us an email and we'll get one to you as quickly as we can. Finally, if you missed any of the lectures in our recently concluded Distinguished Lecture Series on the Crisis in American Constitutional Democracy, you can still see those on our YouTube channel. And as always, you can find out about our upcoming events and other programs at the Foley Institute by subscribing to the Foley Institute YouTube station, liking us on Facebook, or emailing us at tsfoley@wsu.edu. Our guest today is Bob Ferguson, Washington's 18th Attorney General. Bob received his BA in political science from the University of Washington and his JD from New York University Law School. After law school, he clerked for judges in the Eastern District Court in Washington and on the 8th Circuit Court of Appeals. After that, he went to go on to become a litigator at K&L Gates, which is one of the largest law firms in the state of Washington. Bob previously served 9 years on the King County Council, where he was known for his work on veteran services, open space preservation, mental illness, and management of the county's budget. He was elected Attorney General in a statewide election in 2012, and last year he was reelected to his third term in that office. As Washington's chief law enforcement officer, Bob has been a fierce advocate for consumer protection rights, veteran services, environmental protection, and for support of law enforcement agencies. On a more personal note, I just want to note that Bob is, despite being a Husky, I've got to add, is a great friend of the Foley Institute, and each year he makes time to come visit us at WSU's campus. Unfortunately, the pandemic precluded that this year, and I want to thank him personally for taking time out of his busy schedule to be with us via Zoom. Bob's comments today are going to focus on the state's recent lawsuit against Google for violating state campaign finance laws. This is one of several actions currently pending against large social media corporations related to their growing role in our elections. These suits and other efforts to regulate political content on social media raise important questions about free speech on the internet, but also about the transparency and security of our elections. The Attorney General is going to speak for about 20-30 minutes, after which we'll have plenty of time for discussion. If you have questions, I encourage you to send those to me at tsfoley@wsu. Again, that's tsfoley@wsu.edu. So Bob, I'm going to turn the time over to you now, and I'll be back with some questions from our audience later.
Hey, thanks so much, Cornell. Thanks to you, to Richard, to the whole team at the Foley Institute for having me back again, this time virtually. I hope you're all doing well and staying healthy during a challenging time, and really look forward to the conversation. I'm going to try and move through some slides pretty quickly and hit on a bunch of issues, including Google and Facebook and an antitrust case we have against them, but really moving on to some other topics as well. In terms of the questions, really feel free to ask about anything that might be on your mind at all related to the AG's office and the work that we do, and I'm happy to try and do my best to take on any questions you might have. So if you hear me calling out the name Dan, that's Dan Jackson. He works in my office and he's controlling the slides we've got today. So Dan's going to pull those up today and share his screen. So we've got, again, a few slides I'll move through. And really, this is the first part of my remarks will focus on big tech and an antitrust case that Washington State is involved in with a coalition of states across the country that you've no doubt been reading about in the newspapers. And so, Dan, why don't we get started and move on to our first slide. So before I get into that, though, because we're at the Foley Institute, of course, I'd be remiss if I didn't mention former Speaker of the House, Tom Foley, not just because he was really a political giant in Washington State, but as the Attorney General for the state of Washington, I like to take every opportunity I can to remind people that before he was a congressman and a Speaker of the House, he was an Assistant Attorney General in the Office of the Attorney General here in Washington State. In fact, he worked in Spokane, and so we're proud of our association, AG's Office, with Speaker Tom Foley. And before I start getting into the details of our cases, I want to give you an overview of our office, just so you have a sense. A lot of people often ask me, Bob, how big are you guys? What exactly do you guys do So just to kind of ground us in the work of the AG's office, real briefly, we have more than 600 attorneys, about 650, similar size professional staff. So we are the largest law firm in the state of Washington. In fact, we're one of the largest AG offices anywhere in the country. I think we're the 5th largest in the country. So we have a big operation. In fact, we have 13 offices all around the state, including in Pullman. In fact, I was on a Zoom meeting with my team in Pullman just yesterday, talking about the great work they do. And in fact, the work that we do on behalf of the state, think of it in 2 buckets. The largest bucket is we're the law firm for the state of Washington. So we provide legal services to all state agencies, boards, and commissions, of which there's a couple hundred. So as one example, Washington State University, that's one of our clients. We give legal advice to the university. The university, like all of our clients, decide how they want to do things. Our job is give them their options on how to proceed, but they choose. The other part of our work we do, which is more high profile and frankly will be the subject of what I talked to you about today, is work we do directly on behalf of the people of Washington State. So think areas like consumer protection, antitrust, civil rights, criminal justice. In cases like that, federal litigation. In those kinds of cases, and the cases I'm talking about today, whether to file those cases are my decision. It's not the client's, it's not a client, rather, it's not the governor. Those are my decision because the client in a consumer protection case, for example, is the people. It's all of you. And so my job is to make the decisions on whether to file cases in those areas: consumer protection, antitrust, civil rights, criminal justice. Those are the key areas in federal litigation where you see the AG makes the decisions. So one of our 27 divisions, and this will be a bit of my focus today, is our antitrust division. I think it's fair to say that states have, in recent years, taken a more significant role when it comes to antitrust enforcement in recent years. Not every state has a big footprint when it comes to antitrust enforcement in the same way that they do with consumer protection. But Washington, I think it's fair to say, is one of the states that is leading on antitrust types of cases. So just to give you a sense of scale, since I became Attorney General in 2013, we've more than doubled the size of that division. These cases are, as you'll soon see, are very complex, labor intensive, and quite consequential. So we can bring lawsuits. My office can bring lawsuits on behalf of Washingtonians, consumers, who've been harmed by anti-competitive conduct, but they may have limitations on what lawsuits they can bring. So over the past just, I think, 3 or 4 years, to give you a sense of scale, we've recovered more than $100 million for the consumers and the state of Washington, again, just in the last 3 or 4 years. That gives you a sense of scale of how large some of these cases can be. So just to overview of what I'm going to focus on here, I'll talk about these antitrust cases we have against Facebook and Google. Then I've got a couple other cases that I'm going to talk about as well, depending on time. I'm going to keep an eye on my phone and my time because I want to make sure I leave plenty of time for your questions. So feel free to put those questions in the chat as well. And I think Cornell's going to go through and pull some out as we chat later on. So we're going to talk antitrust. A good place to start is with Teddy Roosevelt, known as the Trust Buster. So I think a lot of folks maybe have a sense of what antitrust is, but I think it's always good to get a little grounding in what we're talking about. Teddy Roosevelt, in many respects, said it best. He said, when aggregated wealth demands what is unfair, its immense power can be met only by the still greater power of the people as a whole. And frankly, the people are represented by those who enforce our antitrust laws. What are those laws? In essence, the purpose of our antitrust laws are to protect and to promote market competition. That is the essence of our entire system. And this is important because when you have more competition, when you think about it, what does that lead to? Better products, better services, lower prices, better service, better quality. Those things all happen when you have competition. When you don't have competition, you've got problems. Higher prices, reduced quality, reduced incentives to innovate. If you have the monopoly, if you control the entire industry, you have very little incentive to innovate, and it excludes competition without reasonable justification. So, I think when it comes to antitrust, Thurgood Marshall summed it up well in terms of why we should care about this or how we should think about antitrust laws. Thurgood Marshall said, antitrust laws are the Magna Carta of free enterprise. They are as important to the preservation of economic freedom and our free enterprise system as the Bill of Rights is to the protection of our fundamental personal freedoms. So these laws are critically important, and the state of Washington and other states have a role in enforcing those laws to make sure we have a level playing field when it comes to competition in our system of free enterprise. So I'm not going to spend a lot of time on sort of history of antitrust cases, but I just want you to have a feel for the fact that these cases have been around for a long time. So the key antitrust law, the Sherman Act, was I believe was put in place in 1890 or so. So you saw major cases coming in the early 1900s. So for example, President Roosevelt wanted to prevent the railroads from being monopolized. I think his big stick that he's carrying says greater railroad regulation, I believe is the line there. And so the Supreme Court agreed and said that the railroad schemes were unlawful. He was nicknamed the trust buster for that work. So he saw that consolidated power, those monopolies, as being harmful to the people, to the American people, and he earned a reputation of being a trust buster. And in some respects, that work really kicked things off in terms of the importance of these laws. And look, this strikes close to home as well. Tomorrow is opening day for the Seattle Mariners, I believe. And we have Seattle Mariners baseball in the Northwest because of antitrust laws, quite literally. So we had the Seattle Pilots back in 1969. They left after 1 year. The picture you see there is Slate Gordon. He was Attorney General from 1968 to 1980 before becoming a U.S. Senator. He actually used antitrust laws to sue Major League Baseball when they left for breach of contract, for fraud, and for antitrust violations. That case actually went into a courtroom. The case was going so poorly for Major League Baseball that after a week or two, they offered to settle the case and promised, as part of the settlement, to provide a Major League Baseball team to Seattle, the team that later became known as the Seattle Mariners. Now, some people said the Mariners should have been called the litigants, the Seattle litigants, because they're the only baseball team ever created out of a lawsuit. But again, that was an antitrust case brought by Slate Gordon. I had a chance when he was still with us of talking about that case at length. And it's an example of how important these laws are. In fact, they're in my office. If you want to know a way to get a bobblehead, if you're not good enough to play shortstop for the Mariners, but you want a bobblehead, one way to do it is to be the lawyer that brings a Major League Baseball team to your area. So that's a Slate Gordon bobblehead that I've got in my office. So let's bring this to the current time. We're not talking about railroads today. Our economy is changing. Our economy looks a lot different than it did 100, 120 years ago. So let's talk antitrust in the digital age. So I think it's fair to say, more than fair to say, that the power of today's biggest private tech companies rivals that of government. And they have, in fact, in some sense, they have more daily influence over how we live. Let me just give you a couple numbers. I could give you a whole bunch of numbers, but let's just pick a couple for the sake of moving things along. Facebook, roughly 70% of the US population, including more than 5 million Washingtonians, don't just use Facebook, they use it every day. Google, nearly 90% of all internet searches in our country run through Google's search engine. To put that in some context, no other competing search engine has more than 7% of the market. That's domination in the market for both those entities. So let's talk about Facebook for a moment. Facebook makes money off its users in two key ways: collecting and selling its users' personal data, and then selling ad space on its users' news feeds. And this is very, very lucrative for Facebook. The company's businesses earned $70 billion in 2019, which was a 27% increase from the previous year. So Facebook adopted what's become known as a buy or bury campaign. This campaign was put in effect to essentially take out their competitors before they could become serious competitors. As an example, in 2012, they bought Instagram, and in 2014, they bought WhatsApp. And we're going to talk about how CEO Mark Zuckerberg sees this. He's been quoted, "What we're really buying is time. Even if some new competitor springs up, buying Instagram, Path, Foursquare, et cetera, now will give us a year more to integrate their dynamics before anyone can get close to their scale again." I think we have another quote from him. "One thing about startups is you can often acquire them, and acquisitions would enable Facebook to build a competitive moat or neutralize a competitor." Essentially, it's an anti-competition statement that he's making there. So let's look at one case study. WhatsApp was a popular ad-free messaging app that did not sell user data. How'd they do this? They did it by charging a $1 annual subscription fee to stay profitable. That was it. When Facebook purchased WhatsApp, they promised to keep it that way. That was their promise when they purchased it. That promise did not last very long. They broke that promise. They eliminated the user fee and they started selling the data. That's what happens when you have a monopoly. And what do you lose? Well, rather than improving its services and increasing privacy, Facebook just bought, or to use another word, buried the competition. So that, again, is what is the problem if you have a monopoly, right? They're simply acquiring the competition and not having to innovate. And who loses? The consumer. So in late last year, December of 2020, we joined a coalition, bipartisan coalition of almost every attorney general in the United States. And we filed a lawsuit in the district court for the District of Columbia. So that's where the lawsuit was filed. I'm going to oversimplify a complicated case, but essentially what we're claiming in our lawsuit, all of these states, is that Facebook formed an illegal monopoly in the personal social networking market by buying or constraining potential competitors, usually mobile apps, and they did that in their infancy. As I mentioned, the buy or bury. And without competition, what's the end result is reduced choices for consumers, increasing the number of ads, and weakening privacy protections, all specific harms that consumers see because of those anti-competitive and, in our view, illegal actions. The status of the case is in early March. Facebook filed a motion, papers with the court, asking the court to dismiss the lawsuit. That's sort of a typical first move from a defendant in a case like this, is say to the judge, hey, judge, they don't have a case here. Let's dismiss it before I even get to a trial. So right now we're working to get a trial date. There's been other litigation. The federal government's had litigation against Facebook, as you probably read. So any trial on a case like this, whether from the states or the federal government, would be some time away. That's not going to be this year or even next year. That's going to be quite a ways down the road. And then real quick on Google. In the last decade, Google's revenue from search advertising has grown 300%. To give you a sense of scale, in 2019, search advertising accounted for $98 billion in revenue for Google. That's more than the gross domestic product of more than 100 countries and the budgets of almost every state in the union. So how they maintain dominance. Google uses restrictive contracts to limit general search competition on devices that run the Android operating system. And they use what can only be described as a vast financial resource to maintain that exclusivity. So for example, Google pays Apple between 8 billion and 12 billion, that's with a B, per year to ensure that Google is the default search engine on Apple devices. Why does that matter? It matters because you don't get to choose the default search engine on your device. Again, we're limiting competition. So in December of 2020, again, we joined another bipartisan coalition of state AGs, again, filing a case in the US District Court for the District of Columbia. Again, oversimplifying a very complicated case, but our claims are that Google is illegally leveraging its dominance in the online search and search advertising markets to stifle competing platforms, drive advertisers away from rival search engines, and limit competing specialized sellers' ability to bring customers directly to their sites from general Google search results. So the status of our case there, they've answered our complaint, and we're in the initial stages of what's called discovery. That's where we can ask Google for documents. They've got to turn them over, and we can review those documents. And we have a trial date. I think we're seeking the trial date. I'm not sure if it's set yet, for September of 2023. So again, this is going to be down the road before you get to a trial for a case of this magnitude, as you might imagine. There's also other cases. The Department of Justice was joined by a smaller group of states focusing on somewhat similar claims as well. So what do you lose when all this happens? Hey, when companies buy or bury the competition, instead of improving their products, you lose choices and a true free market that promotes innovation. So that's what these cases are essentially about. And a New York Times writer really summarized it pretty well. Here's what this writer said. What did not happen over the years because of the big tech companies' aggressive maneuvering in reaching market dominance is something we'll never know. All the startups that were crushed, the life-changing products that were never fully developed, the entrepreneurs behind these companies have been scattered to the winds and their products long gone. So there is a cost to market domination. And look, these cases will be hard fought and will take some time to resolve, as you might imagine. But some of the most important lawsuits in our country's history have been antitrust cases to ensure that there is competition in the marketplace. And media reports about these cases kind of already described these as very pivotal cases. So perhaps I'll come back to a future Foley Institute when we can be there in person, give you an update on how this litigation is going on. And Dan, I think we have maybe one more slide. Is that right? So what I'm going to do is briefly, maybe I'll take just about 5 or 7 minutes here, Cornell. So I'm going to want to make sure I leave a half hour for questions. So I do want to give some updates on some other litigation that's going on. I may just focus on a couple of these in the interest of time. And again, when it comes to questions, really feel free to ask about not just what I'm chatting about here today, but really anything that might be on your mind. But I do want to give, there's so much going on in the office, some quick updates. I know in past talks I've given at the Foley Institute, which I think have been now 3 or 4. I think, Cornell, I'm losing track of how many times I've been there. But I know I've spoken a fair amount about federal litigation that we had in the last 4 years against the Trump administration. So maybe just a couple thoughts and updates on that. So we ended up filing in those 4 years almost exactly 100 lawsuits against the federal government. About half those lawsuits were related to one general topic, and that's the environment, that the administration was really systematically rolling back environmental regulations and protections put in place by bipartisan presidents over a number of decades. So that was a big focus of our litigation. 43, I think, of those cases reached a decision by a court, either the trial court, the Court of Appeals, or even the U.S. Supreme Court. We had several cases went all the way to the U.S. Supreme Court. So our record in those cases have been heard by a judge or judges is we won 41 of them and we lost 2 of them. So our track record is pretty good. We can hope that the Mariners come somewhat close to that 41-2 record after 43 games in the season. So we had a lot of success with the cases that we brought. Maybe one thing I'll highlight here that's important to point out is that the work continues in those cases. In other words, it's not as if Joe Biden walked into office in January and our work on the cases that have not reached a final resolution. In other words, they may still be on appeal. Some of those victories we had are still on appeal, or the case had not yet got before a judge for a decision. For the most part, those cases all continue. In other words, a new president, there are exceptions, of course, but I'm speaking generally, cannot necessarily simply with the stroke of a pen undo what a previous administration did. And so as a result, much of our litigation is continuing, even though there's a new president in place. And so I think what's different is we're not filing the new cases. We haven't seen a need to file any new litigation against the federal government since Joe Biden became president, but we have ongoing work going on cases. So for example, just to pick one as an example, we are leading a lawsuit with a group of states related to proposed drilling at the Arctic National Wildlife Refuge. We are leading a lawsuit, a coalition of states on that. That litigation is ongoing. So there's a lot of litigation that falls in that category that is still ongoing and in our view, extremely important. I know in past talks at the Foley Institute, I'm quite sure I talked about one of our cases went all the way to the Supreme Court. I don't think we had a decision when I last spoke there, but we had a case on behalf of Dreamers in Washington State. We have 18,000 Dreamers. The last administration tried to remove protections for Dreamers, which would make them eligible for deportation to countries they don't know or don't even remember. That case went all the way to the U.S. Supreme Court. We co-led that case with the state of New York, and we prevailed at the United States Supreme Court, which was a very important win. Maybe I'll skip down to the opioids litigation. Happy to take questions about the Tim Eyman litigation. All I'll say about Tim Eyman is we had a large campaign finance case against Tim Eyman that was many years running. That case was recently decided by a trial court judge in Thurston County. The state won that case. Every claim we prevailed and issued a penalty against Tim Eyman of well over $2 million and is limiting his ability to be involved in the financial affairs of future campaigns initiatives because he was receiving illegal kickbacks from donations that were made to his initiatives and not sharing that with the public, which you are not allowed to do. Happy to take questions about that case. But I do want to spend the remaining few minutes I have here, Cornell, on opioids and litigation we have around opioids. This is such an important topic. So in Washington State, just to kind of ground this a little bit, in Washington State, like every state in the country, has really been devastated by the opioids epidemic. To give you a sense of scale, on average, in Washington state, 2 people die every day because of an opioid overdose. So that's not having the overdose. That's 2 people who die every day because they overdose on opioids. Over the last several years, we at the AG's office, we have filed numerous lawsuits against entities large and small related to this epidemic. I'll maybe focus on a couple of the larger cases. So, for example, we filed a lawsuit against Purdue Pharmaceutical, owned by the Sackler family. You may have read about that case because other states have filed as well. Purdue Pharmaceutical filed for bankruptcy, so now we're tied up in bankruptcy court. So there's a lot of negotiations going on in bankruptcy court in Florida, actually, which was unfortunate from our standpoint. We had a trial date. We were ready to go to trial against Purdue Pharmaceutical, but now we're tied up in a bankruptcy court. Another series of cases that are coming soon to a courthouse here in Washington state are against 3 distributors of opioids. So these are the companies that distribute the opioids across the country in Washington state. So we filed a lawsuit some years ago, 2 or 3 years ago, against 3 distributors. These are Fortune 15 corporations. These are huge companies. Think Cardinal Health, AmerisourceBergen. These are large companies. And it's our contention that these distributors, these companies, acted illegally when distributing opioids. And just to give you a quick sense of the case, if you distribute opioids in this country, you have a legal obligation if you see a suspicious order. So, for example, if you see a huge number of orders coming in from a very small community, totally disproportionate to the population of that community, well, that's suspicious. Hey, maybe these orders aren't really for pain, maybe it's for addiction. If you see that, you have a legal obligation to not ship the opioids, and you have to notify the legal authorities. That's your obligation as a distributor of opioids. It's our contention these 3 companies did not do that, that in their pursuit of profit and frankly greed, they ignored red flags, which they had a legal obligation to not ship opioids. Shipped anyway, consequences be damned, no matter what the harm was to Washingtonians. To give you some sense of scale, in more than a dozen counties in Washington state, these distributors distributed more opioid prescriptions, so not pills, more opioid prescriptions than there are people in more than a dozen counties in Washington state, which is pretty breathtaking. I don't think you need to be a PhD in opioid distribution to know that's a red flag. And these were counties east of the mountains, west of the mountains, red counties, blue counties, large counties, small counties, big populations, small populations. It really does not fit neatly in any one type of community where we saw this going on. This was pretty pervasive. And so our lawsuits have moved forward. Many states have filed. We're one of the very few states that really sort of litigated these cases. And so we have a trial date coming up later on this year, this fall, against these 3 entities. That's going to be in King County Superior Court. We expect those cases to go forward, and these cases are extremely consequential. We're asking for billions of dollars as a result of the harm. If successful, that'd be billions of dollars that can be used in communities all across our state to deal with prevention and treatment, which is so badly needed for individuals and families and communities that have been impacted by the opioids epidemic. So this is a huge case. When you take on a Fortune 15 company, as you might imagine, of a case of this magnitude, they've got a lot of resources to defend themselves. So it's a huge investment of resources in my office, of my team. They're doing a great job. But I'm sure when we walk into a courtroom, those will be cases of national significance. Other states will be watching those cases very closely. And I'll come back maybe next year to the Foley Institute and give you an update on how that case went. So Cornell, I'm going to stop there. I think I came in right at 12:30, so we got a half hour for any questions that you all have. And thanks again for having me, Cornell, and to all of you for watching. I really appreciate it.
All right, thanks, Bob. That's terrific. I have lots of questions coming in, but let me begin. You outlined the anti-competitive behavior you think that Google and Facebook have pursued. I didn't hear much about the remedies you're seeking. What is it you actually want to see happen to these companies?
Yeah, so a couple things on that. So thanks for asking. I probably should have put that into my slide presentation. So at the most basic level, Cornell, we obviously want these companies to stop their anti-competitive conduct, right? Buy and bury, for example, right? Number 2, as we move forward in this case, I think what you'll see are specific requests, if successful in this litigation, in which they would need to remove themselves from certain parts of their operations, to divest from certain holdings that they have in order to avoid the monopoly situation that we see. And you've seen that in other antitrust cases, in remedies that courts have put in place, and other antitrust cases have been brought. I think that's the kind of thing you'd see in this case as well.
Okay. Lisa Brown, who's director of the Department of Commerce for the state, asks a question. She says, I assume it's difficult to regulate international monopolies at the state level. Could Congress act? And do you have opinions on what actions should be taken at the national level?
Oh, thanks for that question, Lisa. Great to hear from you. So, yeah, yes, Congress has, in fact, I don't, first I'll start by saying that's above my pay grade in terms of what Congress is doing. I got my hands full on just trying to track our own litigation, as you might imagine. That said, it would be a question probably best asked for future members of Congress who come before the Foley Institute. That said, it is my understanding that Congress is looking at different legislative proposals in this area, in this space, particularly around big tech and the monopolization of these companies and the influence they have on our society in multiple ways, as you might imagine. Again, that's a little bit above my pay grade. I don't really focus on that because I focus on the legal side and the enforcement side, and using the tools that I have where I see illegal conduct. But yes, it is my sense that Congress is definitely looking at this as well.
Okay. Denny Johnson in Olympia asks a question about privacy and Google and Facebook. And what he's concerned about is the fact that they make a lot of money off selling our private information. And oftentimes we don't know we're giving consent to do that. And A, should they be prevented from doing that? And B, if not prevented, should it be easier for us to prevent them from not giving our permission?
So I think the answers are yes and yes. If I've heard those questions right, Denny. So let me just elaborate a little bit on that. So yeah, I think I used an example in my slides there of privacy, of the very issue you're asking about, Denny, right? Which is, hey, how can they use my information, or should they be able to use my information? And when there was competition, right, from a rival who was protecting your information, right? When they bought that entity, promising to follow that model, they broke that promise, right? And that's the problem when you have a monopoly. They don't need to protect your information. Well, what's their motivation to do it? They control the market. Someone starts to compete, they buy them up, and they don't have to take those steps that you as a consumer, frankly, I as a consumer, would like to see happen. And frankly, I don't think we're alone, Denny, in wanting to see that. And so it's my belief that the most effective way, and maybe this goes back to the earlier question from Lisa as well, Cornell, is that, look, I'm glad that Congress is giving some thought to these issues. I can't say I have a ton of confidence that Congress is going to act in a way that really protects consumers. I don't mean to be critical, but there's a lot of dysfunction at the federal level on all sorts of issues. And so I hope that they do. I'm just not wildly confident that that's going to happen. And so I think in some respects, Denny, to your questions, it's the enforcement mechanism that I think is especially critical to get where I think what you want. You want a choice, right? You want to be able to provide your information to a company that will protect your information and not share it. But that requires enforcement and a lot of resources on the enforcement side. So, one thing I like to say is you can have all the laws on the books, but if no one's enforcing those laws, they don't do a whole heck of a lot. And so one way at this problem is by this lawsuit. If we're successful, you will see more competition in this space. And by seeing more competition, you will see companies that are listening to what you're saying, Denny, and what other people around the country are saying, that they want greater protections. Maybe one more thing I'll add, which is a little bit beyond the scope, but right here in Washington State, I'm not going to remember the Senate bill number, but there's a bill here in Washington State in our legislature right now. The prime sponsor of that bill is State Senator Reuben Carlisle. And he has a bill that's, as I understand it, is trying to get at obligations of companies that have your personal information not to share it. And so if you have an interest, I'd encourage you to check out that bill by State Senator Reuben Carlisle. It's currently passed the Senate and has moved over to the House. It's actually at a relatively critical junction in that bill. It's been proposed in the past, hasn't passed. It's now moving forward. I think folks have different views about that. So I encourage you to kind of read up on it and form your own opinions. But I think it's fair to say that there's an attempt being made here in Washington State to have additional protections in place for consumers, their personal information that they share with entities. And that bill is worth looking at and weighing in on.
Is that SB 5062?
I think that's right. Thank you for sharing that, Cornell. I think that's the right number.
Right.
And there's been a lot written about it. So if you just Google Reuven Carlisle, state legislature and privacy, you'll find it.
Okay. Nancy Israelis asks a question about some of the election finance cases your office is working on. And I was under the impression that you're also suing Google with respect to campaign finance and the fact that they haven't kept and shared information about the campaign ads that they've been selling. So maybe you can say a little bit about those cases.
Absolutely. In fact, Google and Facebook, both we have litigation against in this area of campaign finance. So let me take a half step back if that's okay. So in Washington State, the people of Washington State back in, Cornell, I think 1970 or 71 or 72, a long time ago, passed an initiative, overwhelmingly, huge margin, that created much of the laws that we have around transparency in our elections. So that initiative has been amended over time by the legislature, but essentially what it means is, hey, if someone writes a check to a candidate for governor or attorney general or one of your local offices like state legislature, the candidate must disclose who wrote the check and how much that check was for. I'm oversimplifying, but you get the idea. And that gets posted every month so everybody can see who all my donors are or any other elected officials' donors are. And that applies for candidates all across the state. There are also requirements for entities who receive political advertising, radio stations, TV stations. So for example, if you're curious as a resident of Washington State, who's buying and paying for a TV ad you might see on the news, you can go to that TV station and literally you can ask TV station, I want to see who's paying for these ads. And the TV station is required to keep the books on that and show that to you. So you can see who's buying the ads and how much they paid for it. There's certain requirements, certain things they have to show to the public and make available to the public. Well, interesting, when those laws were passed, of course, we did not have social media, right? We had radio and TV, and that's where it was kind of a thought of at the time. But of course, technology changes. So getting to the lawsuits we have against Google and Facebook, what's happened, of course, now is candidates, local elections, state elections, you name it, use social media more and more to advertise. That's a great thing. Google and Facebook have an obligation, because that's political advertising. They're accepting money for political advertising, just like a TV station, just like a radio station. They need to disclose to the public who's buying those ads and how many ads are they buying. That's public information under our state laws. Well, it became clear that they were not doing that. So Google, for example, individuals in Washington State went to Google, asked who was buying these ads. They didn't keep the books. They said they couldn't do it, which I'm skeptical that companies as large and sophisticated as Google can't keep track of political ad buying here in Washington State. So we brought a litigation against them maybe over a year ago. I'm losing track of time, Cornell. We settled that case for a few $100,000. Rather than simply following the laws, find a way to follow the law, what Google decided to do was just no longer take political ads. That's their right, that they don't have to do it. But they said, we're just not going to take the ads anymore. There's just one problem. They kept accepting ads despite saying they weren't accepting ads. And so that led to another lawsuit that we filed just recently that you probably read about and is probably the focus of the question. So we filed that case, and our contention is quite simple, that they are no different than a radio station or a TV station. If they're taking in political money for political ads, you've got to keep certain things on the books, just like those TV stations do, just like a small town radio station must do. Google's got to do the same thing, and they're not doing it. So what they're saying is they're no longer accepting the ads, but ads are still getting through. Quite a few ads are getting through. And that's what the lawsuit is about, that transparency in our elections. So it makes it frankly tough for candidates, because some candidates get their ads through. Well, that's kind of unfair to someone who's playing by the rules and not turning their ads into Google because they know they're not accepting them, but then some slip through, which is unfortunate. But frankly, Google needs to get their act together, right? If they're not going to take the ads, don't take the ads. Don't let some slip through. And I just find it impossible to believe that a company as sophisticated as Google can't get this figured out.
Yeah, so Randy Bolojak asks a question that sort of follows on from that. And that is, he says, by regulating these big social media corporations, and in particular, if you make it harder for them or more expensive for them to run political ads, is that going to have the unintended consequence of disadvantaging, candidates who are not well financed, disadvantaging poor candidates?
Just because we're not making it harder for Google to do anything. All I'm saying is Google's got to follow the law in the same way that the Pullman radio station's got to follow the law. In the same way that a TV station in Eastern Washington's got to follow the law. Why is Google special? Right? The people enacted a law that's pretty straightforward. If you accept political advertising, guess what? The people get to know who's paying for those ads and how much they're paying for. It's a pretty simple proposition. So what? I'm supposed to say, yeah, all these small radio stations and newspapers, they've got to figure out the books. They've got to figure out, but Google, no, you're too complicated for you, Google. We'll give you a pass. That's not how it works. So it's not my job to tell Google how to figure out how to do their job or how to follow the law. My job is to make sure that everybody follows the law. It's not fair that only Google gets an exemption from what I think are very clear laws in our state. And so what I would say is, look, I hope that they get it together and can figure out a way to disclose the basic information that everybody else does. So it does not, obviously our lawsuit isn't about any particular campaigns or who can or can't. It's about Google, right? And about Facebook and about their obligation to provide that information to the public. And frankly, what I would add is we've seen with elections in 2016, otherwise, the influence of other countries in our elections. Hey, there's a reason why these laws matter to have transparency. There's a reason why these laws are there to show us who is buying those ads. So I think we've learned some hard lessons about not having transparency in elections and what that means for us as a nation, of who's influencing our elections in some ways in a way that is inappropriate. And so the people were wise in Washington State to enact these laws. And I mean, honestly, to say it bugs me that Google and Facebook can't get their act together is an understatement. These are huge corporations, billions of dollars. They have all the resources in the world, and they can't do what the Pullman newspaper, the Spokesman Review, the Seattle Times has to do, what TV stations have to do. You know, give me a break, right? Follow the law. It's not complicated.
Julie Iannelli asks, if litigation against Google is successful, what do you anticipate happening if those paying for ads on Google do not wish to promote on various search engines?
Do you mind repeating that one more time? So this is on the antitrust case. I had my mind was on campaign finance. Do you mind just doing that again?
She asks, if your litigation is successful against Google, what will happen for those who are paying for ads on Google if they don't wish to go to other search engines?
I guess I'm not sure if I can answer that specific question, right? But one thing I'll say just more generally is sort of the specific remedy that will come into play at the end of what's going to be a long case, I think frankly remains to be seen, right? We'll be going through a discovery process to learn a lot more about how this works, what specific actions Google and Facebook have taken, which when you get to that point, after you've prevailed on the legal side, assuming we do, then you get to the remedy side, right? So that's a whole nother part of a case will be what is the appropriate remedy given what we think is illegal conduct and assuming a judge agrees with us. So what the specific consequences would be in a specific instance would be impossible to predict right now. But what I can say for sure is that both Google and Facebook would have to make significant changes to the way in which they do business in the same way that Microsoft had to make significant changes the way they did business as a result of an antitrust lawsuit brought against Microsoft, as you may recall, a few decades ago. So the specific remedy and how that might impact consumers, I think too soon to say what that in that level of detail, but would become more clear when we get to that stage of a trial, but that's some ways down the road.
Okay. Let me go back to the campaign finance or campaign laws more generally in the state. Are there any state laws that regulate the content of political ads? And I'm thinking here in particular about misinformation and the fact that some social media companies like Twitter and Facebook crack down on the stop to steal messages that were sent out on social media. Is there anything at the state level that prevents blatant misinformation in political ads?
I mean, there has been some litigation around, for example, sometimes candidates file lawsuits against other campaigns, right, for what the other campaign says about that candidate. Maybe it's untrue, for example. Or more specifically, we've seen litigation or cases brought even by the PDC where a campaign or a third party who's engaging in political speech, right, trying to influence election, does not accurately disclose who's paying for the ad. There are certain requirements on any political advertising, who's paying for it, right, and information about that. My office has brought litigation against individuals who misled the public on who is actually paying for an ad. So you have a certain disclosures up front But in terms of that specific context, yes, sometimes you see cases, but it's extremely difficult. I will just say, and I'm just going to take a little more broadly, if that's all right, Cornell, is that in the public sphere, particularly of elections, right? There's a pretty wide berth that's granted for the free flow exchange of ideas on that. But folks at the Public Disclosure Commission, they're the ones who write those rules, who set those regulations. And so frankly, I would defer to them. They are the experts. They are the ones who put those rules into effect and could best answer any sort of specifics around that.
Okay. Ali Figlin asks a question about free speech and these ads. And I suppose one of the questions she has is whether or not requiring people to disclose who's paying for the ads is a violation of free speech rights. Do people have a right to not have to disclose that they're engaged in political speech?
Yes, Ali, so courts have looked at that, right? That these laws have been on the books for, like I said, I think close to 50 years now. So I guess what I would say is that many aspects of our campaign finance laws in Washington state have been challenged. My office has been a part of some of those cases. Maybe I'll talk about that here in a moment. But there's been litigation, there have been court decisions at all levels of our court system here in Washington state around all sorts of requirements under our campaign finance laws. So I think what I can say is that, yes, that requirement that the state's interest in having transparency outweighs sort of the idea that someone can anonymously put this stuff out there, or you can run for office and not disclose who your donors are, right? The courts have looked at this. And that has, by the way, been some, pretty high stakes litigation. We brought a lawsuit, for example, a few years ago against the Grocery Manufacturers Association. It involved over $10 million of political ads purchased by the GMA around an initiative that we had here in Washington state. It was a food labeling initiative several years ago. This is a high profile case. It was a close initiative. The initiative failed, and we became concerned that this Grocery Manufacturers Association did not disclose who actually paid for these ads, that they essentially created a shell entity to hide the actual donors, Coca-Cola, Nestle, Pepsi, huge entities who donated millions of dollars. And so we filed a lawsuit. That case went all the way up to our state Supreme Court. The penalty the judge imposed was record-setting. It was $18 million, largest campaign finance penalty, not just in Washington state, but anywhere in the country, federal, state, local, anywhere. So it went all the way to our state Supreme Court, where we prevailed. But it's fair to say the GMA literally challenged all aspects of our campaign finance laws, right? And so some of the issues you're talking about, yes, those are issues that have been litigated and are still litigated to this day. And we see that in all kinds of, at the US Supreme Court. Hey, can there be limits placed on how much someone can donate to a campaign? So this whole space of campaigns, what must be disclosed, what doesn't have to be disclosed, those are getting litigated in courts all the time. I think what's maybe the short answer is in Washington state, for our campaign finance laws, which I think are fair to say are pretty robust compared to most states here in Washington state, that those have been upheld. The key elements of those laws have been upheld in Washington state, despite challenges that have come over many, many decades.
Okay. A couple of weeks ago, we had Kim Wyman with us, and she was talking a little bit about the 2020 election and the allegations of election fraud and irregularities in the election. And she mentioned the Lauren Culp case. Now, your office played a role in that case. I wonder if you could say a little bit about that.
Sure. So, yeah, interesting case. I guess a couple of thoughts, Cornell. Feel free to ask a follow-up to this. So, just to sort of set the stage a little bit. So, Kim Wyman, obviously our Secretary of State, she's my client in a situation like this, right? That she's the Secretary of State. The lawsuit challenged the election results. So Lauren Culp, who ran as a Republican for governor and lost, challenged the election results in court. And that was filed here in King County Superior Court. So a broad claims of election fraud here in Washington state. So this would have been the kind of case, Cornell, where obviously it's a high profile case and I'm having direct conversations myself with Secretary of State Wyman. So this would be the kind of case where we're having a conversation about it and chatting with her about how we're going to proceed. What was maybe what's most interesting about that case is that something unusual happened in that case, which is when it was filed, I was meeting with my legal team about it and asking what they thought about the claims made by Lauren Culp in his campaign. And it became very clear after reviewing the allegations, which were sweeping allegations of fraud in Washington State, that my team felt that there was really no merit to the case. I remember asking them, it's an unusual step for any law firm or us as a law office when someone files a lawsuit against you or your client to go to the court and say, hey, court, hey, judge, these claims are totally without merit. They have no basis to bring this claim. And if there is a case like that, if someone's just simply harassing your client, for example, as a lawyer, you can go to the judge and say, this case is frivolous, essentially. And judge, you should sanction the other side for wasting your time and our time by filing this. There's no basis of fact. And so we came to the conclusion that this case from the Culp campaign was that kind of a case. It was truly frivolous. And so, but it was going to cost us, the taxpayers, a lot of money to defend that case. And so I said to my team, let's file that motion saying this is frivolous. Before doing that, what we do as an office, as a courtesy essentially, is we notify the other side that we're going to do that. So we said to the Lauren Culp, his lawyers, we said, we're going to file, I think we actually sent the motion to him, if I recall correctly, we had it drafted. We're going to file this tomorrow in court unless you withdraw your lawsuit. So they could have kept with it and taken their chances for the judge ruling whether or not it's frivolous, but the Culp campaign chose to withdraw their lawsuit with prejudice, which means they can't bring it again. So they stood down. So they realized what we're going to do, which was frankly hold them to account to say, hey, well, what is the evidence for you to walk into a courtroom with these frankly outrageous claims? And so that saves taxpayer money. But also, I think it is maybe just going maybe a bit beyond the question a little bit, Cornell, but there's just a lot of talk nationally about elections and claims of fraud in elections at all sorts of levels. It's my feeling as Attorney General that that when appropriate to take that on. And it's unusual for us to say to another party, your case is frivolous and we're going to seek sanctions against you if you proceed. I maybe we've done it before in my time, Cornell, but it's extraordinarily rare, right? But this was a rare case. And so I think the Culp campaign made the right decision. I believe had they gone forward, they would have been sanctioned by the judge for those claims. I think they realized that. There's no doubt they realized that. And I guess what I may be enlarging that just a little bit more is we see that at the national level as well. A large number of my colleagues, Republican attorneys general, right at the end of the last campaign in the legal challenges that were going on to the presidential election, filed a lawsuit directly at the U.S. Supreme Court, challenging, this is a case led by the Texas Attorney General, challenging election results in other states, Georgia, for example, right, in other states. And look, I'm just being honest, that was a frivolous lawsuit. We responded to that, a group of states responded to that. The Supreme Court kicked it out immediately. Frankly, I wouldn't have minded if we made the same request there, asking for sanctions against them. It was that outrageous. There were a few Republican attorneys general, to their credit, who did not join that lawsuit despite great political pressure. The Idaho Attorney General, Lawrence Wasden, did not join that lawsuit, for example. I've known Lawrence for many, many years and have great respect. Although we have a lot of differences about our views of the world, to put it very mildly, I have great respect for him as a principled individual. And he did not join that lawsuit, and at, I suspect, great political cost. So, but it was incredibly disappointing to see so many AGs join a lawsuit like that. That was in some ways an equivalent of a state one here with the Lauren Culp campaign. Sorry for the long answer, but I've got strong feelings about it, as you might imagine.
Right. No, I did the Larry Wasden case is an interesting case because the legislature's trying to, I think, punish him right now in terms of his budget and other.
Well, it's exactly right. That in response to him being right, by the way, right, not wasting taxpayer monies to join that thing. His point also was, wait a second, why would I join a lawsuit interfering with some other state's election? What he said to people in Idaho was, how would we feel if California, right, or some other blue state tried to interfere with our elections here in Idaho? We'd be outraged by that. That's not their place. And so, but literally the response from the Idaho legislature is to remove his powers to bring certain cases. They've defunded his operation. They're going to hire more private law firms to represent the state of Idaho, which is insane. And it's going to cost taxpayers more money. And anyway, I'm digressing a bit, but it's a big problem right now when it comes to sort of the politicization of AG offices. There's been a lot of action in legislatures around the country around defunding and taking away the AG in Iowa, Democrat Tom Miller, has been AG for more than 30 years, had certain authority removed from him in the last 4 years. So this is frankly not uncommon, but I'm glad in Washington State we've managed to avoid that, because the AG's office has just got to be, doesn't mean people are going to not necessarily disagree with decisions I make. I get that's a part of it, but you can't have it politicized in that way. That's just asking for trouble.
Let me follow up on that, because this is actually an area I'm interested in, and I've done some writing on it myself in a previous life. But part of that politicization might be the consequence of the increasing likelihood that state AGs are banding together in litigation, much like the litigation you're pursuing against Google and Facebook. Where in earlier times, they would not have sought that kind of national style legislation or regulation of companies. They would have left it to the Department of Justice to enforce federal antitrust laws. So is there a cost to this kind of concerted, coordinated effort on the part of state AGs?
I mean, I don't think so is my short answer. And let me elaborate on that a little bit. So one thing I love about the law, and there's many things I love about the law, but look, if you don't have a good case, you're going to lose, and you're going to lose fast. Okay. And so whether states are banding together on opioids litigation, right, antitrust enforcement, consumer protection enforcement, typically we work together. And by the way, in almost all cases, these are bipartisan cases. So the federal litigation is different in terms of Trump administration, Obama administration. There you see Democratic AGs against Trump, Republican AGs against Obama, right? And now Republican AGs against Biden. Setting that big area aside, virtually everything else we do is bipartisan, all in the rest of it. And so what I would say is that that we are wasting our time if we spend time on a case that doesn't have merit. And so the proof is in the pudding, right? The cases we bring, if we have a successful outcome or we do not. And if we were not having those successful outcomes, there might be a different conversation around states banding together. But the reality is states sometimes need to band together, because if you are taking on some of these large entities like a Google or a Facebook, look, I've got a great antitrust team, but we're talking about a very small number of people. If you're trying to take on Google or Facebook, good Lord, it's not a fair fight, right? And so by definition, or in reality, I should say, states, in order to level that playing field, need to band together to take on the largest corporations. Maybe something else I will say is that, Charles Krathheimer, who's a conservative columnist who passed away, I think, a couple of years ago, he wrote a column about AGs. He was kind of focused on Democratic AGs doing work at the federal level, but he kind of asked almost your question, Cornell, a little bit different, but it was similar about, hey, what about these AGs who get together and do this kind of thing? Is this the way it should be? And his answer was, while he disagreed, he was kind of focused on the federal litigation. While he disagreed with what the Democratic AGs were doing in terms of what specific cases they were bringing, he said the reality is that Congress has largely abdicated their role as a check on the executive branch, that our system of government is set up in a certain way that has checks and balances, right, as we all know, and that Congress is supposed to be a check on the executive branch. What he wrote about was, well, Congress has really abdicated that role. As a result, these AGs are stepping into that role and enforcing and being a check on the executive branch. He said, you may not like what they're doing, but they are filling a necessary constitutional role. And I would say even broadening that out to these other kinds of cases. Look, we need more enforcement in our society. The challenges for consumers, for residents of our state and our country, the need to make sure that powerful interests play by the rules is even more important now. And the number of entities or individuals who can actually do that is very small indeed. And state AGs, I think, the power and influence of state AGs is only going in one direction, Cornell, right? 30 years ago, hey, kind of sleepy state lawyers for their states. Those days are gone. They're distant past. They're never coming back, right? Folks like Chris Gregoire really helped reinvent the AG's office, taking on tobacco companies. That would have been like unheard of 50 years ago, right? But taking on tobacco companies, and what's the result? Billions of dollars for the state of Washington that still come in, by the way, from tobacco companies every single year. And so that's never changing, but I think that enforcement is needed. And look, the reality is just in Washington State, in our office, we've returned hundreds and hundreds of millions of dollars to consumers because powerful interests don't play by the rules, and we are able to enforce their rights, because an individual really can't take on a powerful company. It often takes states working together to bring some semblance of a level playing field in this area.
Okay, I still have several questions, but I see our time is up. It's, as always, been a fascinating discussion. We really appreciate you taking time out of your day to be with us today, Bob.
Hey, great to see you all. Go Cougs, and hope to see you all next year in person in a post-COVID world. Stay healthy, everybody. Great to see you all.
Thanks again. We'll see you all at our next event.